trademark rights, it's really a source identification. It's not about the functionality of the goods, it's not about the technical details of the goods or service, it is a source identification. Trademark, this is your brand. I mean, these are the brands that we all know and can appreciate. But trademark rights are designed to protect that emotional connection that a consumer has with the brand. Okay, all about the source identification. So the Apple sign, Apple, the Coke bottle is actually a trade dress, a type of trademark. Dell, logos, words, symbols, things that identify the source. Okay. Now, what about, what makes a strong trademark versus a weak trademark? Well, if you do any Google searching on trademark strength, you'll get this strength spectrum. On one end, you have very generic, descriptive words, very weak trademark protection. So I'm not entitled to a trademark that just says legal services. It's completely descriptive of what I provide. All right. I may have trademark protection to something a bit more arbitrary or fanciful, Peregrine. Peregrine identified as legal services. That word has really nothing to do with legal services, but it could establish a connection between the consumer and the services that I provide. Okay. Now, if you think about this, we're talking about your brands. You don't necessarily want to be, you want to be unique in that, in some respect. Okay. It might be nice to have trademark protection in legal services, but the law recognizes that that would limit the ability for other legal service providers to communicate, frankly. So we don't give protection to very generic or descriptive words or phrases. We do give protection to something that's a bit more arbitrary and fanciful. Nike, it's not necessarily descriptive of any particular good or service. It's descriptive of it. The other piece of trademarks is the law doesn't want confusion in the marketplace. So one trademark shouldn't be confusingly similar to another trademark because, well, that would be very difficult for the consumers to identify. Okay, well, how do I know this good or service is the quality and the type that I'm accustomed to? So you can't have trademarks that are confusingly similar to each other. What types of trademarks? And you've seen this, I'm sure. There's the TM as a superscript or the R in a circle. It just identifies different types of rights. There's common law trademark rights. Trademark law arises in the United States by use in commerce. You use a brand associated with some good or services that you're offering in exchange for revenue. That's a use in commerce. It just arises through that use. At that point, you're not necessarily required to file for a trademark application or a registration. You just have those rights available to you. You can, if you elect to, file for a trademark registration with the U.S. Patent Office. If that is approved, then you of course get to put the R in the circle next to your logo and your trademark. Okay, two different rights cover the exact same thing, really, but their remedies are a little bit different, and there's some additional protections that you have with registration. One thing that's important to know, especially if your business is a bit service-oriented and geographically focused, your common law rights are only extend to that geographic range of which you're operating. Okay, but what if you file a trademark application with the U.S. Patent Office and it gets approved? You have a presumption of nationwide rights. Okay, so it's an important distinction. There is certainly value here, but keep in mind your rights do arise by using it in commerce.